A lot of asylum seekers who receive a referral notice from USCIS make the same calculation. They went through the asylum interview, maybe with an attorney, maybe alone, and they survived it. True, they didn't get the result that they wanted from USCIS, but look, they know their story, they've already explained everything once, and now they figure, well, immigration court is just kind of the next step, right? Just another administrative part of the process. They think, I'll handle the first hearing, that master calendar hearing, on my own, and maybe then I'll get serious about hiring a lawyer closer to the individual hearing. Look, I understand that thinking, but it's wrong. And in 2026, it can cost you everything. Immigration court is not just another interview. It's not anything like your process before USCIS. You see, for starters, the affirmative asylum interview with USCIS, it was non-adversarial. No one was arguing against you, but immigration court, it's the opposite. There is a government attorney, a prosecutor from ICE, whose entire job is to get you deported. And right now, under the Trump administration, that attorney has a new weapon that they're using, including sometimes at the very first court hearing, before you ever get the chance to explain your case, that can actually end everything that same day, resulting in a deportation order being issued against you. I'm going to show you exactly what happens when someone walks into the immigration courtroom without representation, the specific risks at each stage, the specific mistakes that cost people their cases, and why the stakes right now are higher than they've ever been before. And we're starting right now. I'm Brian Manning, and I used to be an asylum officer with the government. I adjudicated thousands of immigration applications during the 11 years that I worked for the government's two main agencies for asylum and refugee matters. But now, as an asylum lawyer, well, my law firm helps immigrants all over the country to secure their future in America through asylum. Let me know in the comments, by the way, if you have a defensive asylum case pending in immigration court right now. I especially like to hear from you if you've been thinking about handling any part of it on your own. Okay, by the way, if you haven't seen my video on what a referral notice from USCIS actually means and what changes when your case moves from USCIS over to immigration court, please check out that video first. The link is down in the description. Let me walk you through what actually happens to unrepresented respondents at each stage of the immigration court process, because the risks are different at different points, and I want you to understand all of them. Okay, the first risk can hit at your master calendar hearing. That's the name for the first hearing. Now, a lot of people think that the master calendar hearing is just going to be some kind of administrative appearance. Nothing substantive, no big decisions, just kind of checking in with the court, right? Well, that assumption is no longer safe. You see, under the Trump administration, ICE attorneys are now frequently filing what's called a motion to pretermit, including sometimes at the master calendar hearing stage. Now, what does that mean? Well, in plain terms, the government attorney is asking the judge to issue a deportation order without ever giving you a full hearing, no chance to actually explain your case. They typically argue that your original asylum application was not adequately filled out, or that you could supposedly seek asylum in a third country instead, so you should be sent to one of those countries. And yes, ICE is in fact sending people to places like Central African Republic and Ecuador, even though people have absolutely no ties to those countries. And look, if you walk into your master calendar hearing alone, and the government files one of these motions, a motion to pretermit, well, you've got no attorney to identify it for starters, no attorney to object, no attorney to argue why it should be denied. The immigration judge may rule in ICE's favor right then and there. You could receive a deportation order at your very first court appearance, blindsided, without ever getting the chance to actually tell your story. This is not a theoretical risk, okay? It's happening in immigration courts across the country right now. This particular type of motion is hard to overcome, I gotta be honest with you, but to be sure, it is possible. My law firm has defeated it. By the way, if you want to maximize your chances for asylum success, then be sure to hit the subscribe button and the bell notification so that you don't miss the insights that I share on this channel. Okay, the second major risk comes at the merits hearing itself. We're talking now about the main hearing in your case, sometimes referred to as an individual hearing or a merits hearing, where you testify and the immigration judge decides your case. Cross-examination by an ICE attorney at this hearing is an experience that most unrepresented respondents are not prepared for. The ICE attorney, the prosecutor, they have access to your entire immigration history and they scour your asylum application materials, okay? They know where the gaps are. They know where the dates are inconsistent. They know where your story has weaknesses, and they will press on those weaknesses hard in front of the immigration judge, okay? They will ask questions purposefully designed to confuse you, to make you contradict yourself, to make you look like you're not telling truth. Without an asylum attorney by your side who prepared you for this, who knows how to object, who can redirect after damaging cross-examination, well, you're absorbing all of that pressure alone. I've seen what cross-examination does to an unprepared witness, and it's not pretty. You see, it's not primarily about whether your story is true. I mean, that's the minimum requirement, right? But by itself, it's not enough, not even close. A true story told by an unprepared witness under sustained pressure can come apart. Dates get confused, small inconsistencies can get amplified. An experienced ICE prosecutor knows how to make a truthful person look unreliable. Without an attorney who has walked you through your own testimony, who has rehearsed the hard questions with you, and who's sitting beside you in that courtroom ready to object and redirect, well, you're in for a long, difficult day. That's why proper preparation, including intensive practice with an attorney and legal support on the day of your hearing, are so important. Now, the third risk of going it alone in immigration court concerns supporting documents. You see, in immigration court, the ICE attorney can submit evidence in a legal brief arguing why you should not receive asylum. And if you're unrepresented, well, you almost certainly have not submitted a legal brief in your case, and you may not have properly packaged and introduced any supporting evidence that you're trying to get in front of the judge. The immigration judge will weigh what the government puts in front of them against what you put in front of them. And if that record that you're submitting is thin, like no legal brief, incomplete evidence, a declaration that was never structured for courtroom scrutiny, well, the outcome reflects that, and you're doing yourself a huge disservice. All right, the fourth risk is one that most people never even think about. Procedural mistakes that can ruin your case. Missing a filing deadline, not knowing how to properly request a continuance, submitting filings the wrong way, failing to object at the right moment, failing to preserve the right to appeal. These are not minor oversights, okay? They're technical legal mistakes that can close doors permanently, including the door to an appeal if you lose your case in court. Now, an experienced asylum attorney knows these rules, and they stay on top of all of this. An unrepresented respondent is expected to know them too, even if they've never set foot in a courtroom before. Look, the gap between what you don't know and what you need to know is where cases fall apart. So let me be direct. Going to immigration court alone means arriving at your master calendar hearing without protection against a motion to pretermit or other action the government may try to take against you at that hearing that can undermine your case. It means testifying under cross-examination without preparation at your individual hearing. It means presenting your full case without a legal brief, and it means navigating a formal legal proceeding without knowing the procedural rules. Look, in the current environment, some of those things can end your case before it ever really begins, and you'll miss a real opportunity at securing your future and peace of mind in the United States. Look, a study from a couple years ago showed that people with a lawyer in immigration court were about 3 times more likely to win their case than people without a lawyer. And I have to imagine that it's even more heavily tilted towards represented people now under Trump 2.0. So look, if your case is in immigration court and you're considering handling any part of this process alone, please call my office today. Let's talk about it, okay? The number is 713-909-0401. And remember, we help people all over the country, so it doesn't matter where you live. Call us right now to schedule an asylum strategy session so we can help you to secure your future in America through asylum. Again, I'm Brian Manning, asylum lawyer and former government asylum officer, and it's an honor to serve you in your asylum journey.